Okay, we're live.
Somebody my age, that's something good to hear. So, good evening. My name is Gary Darnielle. I'm a Salem hearings official. For the record, it's 5:30 on September 24th, 2025. This evening, we have one hearing on the docket, and that hearing concerns an application for conditional use permit for a short-term rental on property zoned RS at 4936 Pullman Street, Pullman Avenue, Southeast. The applicant is Ms. Rochelle Flanagan, and this is case number CU 2507. Before we get into the staff report and testimony, I need to explain the procedures that we follow and the legalities that are associated with these hearings. It's a little bit boring, but just think of it as one of the benefits of your application. These hearings are characterized as being quasi-judicial and de novo. By quasi-judicial, that means there are certain due process rights that attach, such as the right to notice, not just to yourself, but to the public surrounding the property, the right to an impartial decision maker, the right to a decision that's in writing and addresses findings of fact and conclusions of law. By de novo, that means any new evidence or argument that is relevant to the approval criteria will be considered by the hearings official in their decision. The rules of evidence that you see in circuit court aren't really followed here. We're a lot more flexible in that regard. Evidence that's admissible is that which, such as a reasonably prudent person would use conducting their serious daily affairs. It's important to note that you need to raise any procedural or substantive issues at this time, or if my decision is appealed before the Planning Commission. Failure to raise an issue, whether it's procedural or substantive, with a sufficient amount of specificity to allow other parties to understand the nature of your concern will preclude your ability to raise those issues on appeal to the Oregon Land Use Board of Appeals. What the appeal process is if my decision is appealed, it goes to the Planning Commission usually. And after the Planning Commission issues their decision, that decision can be appealed to the Oregon Land Use Board of Appeals, or LUBA, they should probably understand it to be called. It's important to get out all the issues into the record at this stage of the proceedings or on appeal to the Planning Commission. Burden of proof lies on whoever raises a position or a fact. The ultimate burden of proof lies with the applicant to show that all of the approval criteria have been met or can be met with conditions of approval. The record in these matters consists of the application, any supplemental material that the applicant has provided, testimony from the public in writing at this stage, staff report, and testimony written and oral that we receive at this hearing. You have the right to request that the record be held open an additional 7 days. If that request is made, it needs to be made before the hearing closes. Then we decide how long the record should be held open, because we also have to allow all the parties to have an opportunity to review any new evidence and comment on the evidence. Ultimately, the applicant gets the last word in terms of summary or rebuttal. You also have the right to request a continuance of the hearing. There's another hearing on the same matter in the future. That determination is discretionary with the hearings official. You need to demonstrate why merely holding the record open a certain period of time isn't adequate to satisfy your concerns or your needs. We record testimony electronically. So we ask that when you testify, you use the podium to my left, your right. And that as a preface to your testimony, give your name. Ultimately, if this decision is appealed, whoever is reviewing the record will want to know who's testifying. In terms of hearing procedure, we begin with the staff report. We have Mr. Quincy Miller, who's authored the staff report and will summarize the same. Following the presentation of the staff report, there'll be an opportunity for the applicant to testify. I do have a few questions of the applicant. Then, if there's others in the audience who wish to testify in support of the application, we'll hear their testimony. Following that testimony, sometimes people wish to testify, but the other hand be identified as being in favor of or opposed to an application, and we allow them to testify or ask questions. And then finally, there's an opportunity for those who wish to testify in opposition. Following that testimony, I'll turn to staff and see if staff wishes to address any issues or questions that have been raised. And there'll be an opportunity after that for final rebuttal or summary if the applicant chooses to do that. As I indicated, my decisions can be appealed to the Salem Planning Commission. You have 15 days from the date of notice of the mailing of my decision to make that appeal. The appeal is de novo. Again, what that means is new issues for facts and evidence can be raised before the Planning Commission. Finally, as I indicated, one of your due process rights is to an impartial decision maker. So let me take the opportunity to declare that I've had no ex parte contacts, nor do I have any actual or potential conflicts of interest. An ex parte contact is where the decision maker has communications with a party to a matter the hearings official is hearing that goes to the merits or the substance of the matter and occurs outside this public matter. I've had occasion where people have stopped me in Safeway and wanted to provide some testimony, basically, and I can't listen to that, although sometimes you can't prevent it from happening. If it does occur, then I need to disclose the nature of that communication and indicate whether it's maybe partial. And in any event, I need to allow the public to challenge my impartiality. Conflict of interest has to do with whether my decision would benefit myself, a family member, or a business that I'm associated with financially, or my decision would prevent a financial detriment to myself, a family member, or a business that I'm associated with. I've indicated no to both of those. You have the right now to challenge my impartiality or the jurisdiction of the hearings official this matter. And you retain the right to challenge my impartiality at any stage of the proceedings. Hearing no challenges, let's move on to the staff report. All right, still awake?
I'll do my best to tell a story through words. Excuse me. So, excuse me, sorry. So I'm Quincy Miller. I'm a planner with the City of Salem, and this is presenting on conditional use permit CU 25-07 for 4936 Pullman Avenue Southeast. And to kick things off, this presentation, along with any testimony, will be added to the record.
So accepted.
Yes. All right. So, as I said, this is for the conditional use permit, which is required for a short-term rental in the RS single-family residential zone. So it is a allowed use, however, it does require the conditional use permit. So this property is an existing single-family dwelling in South Salem, close to Boone Road and Liberty Road South, and it is surrounded by other RS single-family residential zone properties, with a few RA residential agricultural zone properties to the south of Boone Road, which is about a block away. So it's mostly in a lower density single-family residential neighborhood. The proposed development in this case, there is no exterior changes or any other modifications to the property proposed. It's an existing approximately 1,300 square foot, 3-bedroom, single-story dwelling with about 500 square foot, 2-car attached garage. That also has about an oversized driveway that leads to a screened off-street parking area in the back. And, part of the conditional use approval criteria. So as I mentioned, if it's allowed as a conditional use in the zone, then it meets the criteria, which this does. The reasonable likely adverse impacts on the use to the immediate neighborhood can be minimized through the imposition of conditions. We've added several conditions inspired by the accessory short-term rental, special use items. And so then, that basically helps mitigate any potential conflicts to the immediate neighborhood, which also ties into the third approval criteria, which is the proposed use will be reasonably compatible with and have minimal impact on the livability or appropriate development of surrounding property. So in essence, this property will still, resemble and mostly function as any other single-family dwelling in the neighborhood due to the imposition of conditions, such as the maximum of 6 guests for the property. So it's 2 per bedroom. Children under 12 years old do not count towards this total. Bookings can only be for one group of guests at a time. There won't be any overlapping bookings. The use of the property will be limited to lodging. No events, parties, or anything will be permitted at that property. And it will be following the quiet hours for the city of Salem, which is between 10 p.m. and 8 a.m. Part of the testimony, there was no testimony from any public agencies or the neighborhood association. There was a public comment which had concerns regarding property values, security, impacts to the neighborhood. And those comments are addressed in the staff report as, in theory, the conditions that were added as part of this conditional use permit, they help mitigate any of those concerns, or there's no applicable criteria for it. As for concerns such as sanitation, those are, general property upkeep that would be applicable to any residential property. So if there's overflowing trash or the property is not being kept up, that would be the same standard that would apply to any other dwelling within the city that would be enforced by our code compliance division. And that's pretty much it. The staff recommendation is to approve it with the recommended conditions of approval.
So I've communicated to staff the fact that we have a police force and there's violations for abusing the sanitation laws, et cetera, really don't address the criteria. I mean, that's too late. The approval criteria look at whether there's any adverse effects that would lead to that. And so that's what I'm focusing on. And that's why I'll have a few questions for the applicant.
Yep.
Do I just state my name?
Yeah.
Okay, my name is Rochelle Flanagan, not Sampson anymore. And I'm the applicant for the property at 4936 Pullman Avenue.
Questions? Is this your first short-term rental? Do you have experience in the area?
I do have experience. This is not my first short-term rental. I actually have another rental in Kaiser. That's a short-term rental. Kaiser does not have the same criteria and licensing requirements as the city of Salem does. We also own a property with my mother in Tillamook, and that one is licensed through the city of Tillamook, and that one is also a short-term rental. And then I'm very familiar with, I have managed them before in the past for other property owners. So yes, not my first.
How long have you had the Kaiser?
We bought that one in 2020, and that was bought as an investment property. It took 4 or 5 months to renovate the whole thing, and then it was listed as a short-term rental from there on. So it's been about 2 or 3 years ongoing. So yeah. The one in Tillamook we bought in, I think 2019, 2020, and that took a year since it was far away. We remodeled that whole property as well. And that was listed immediately as well. And so again, another one for about 3 years or so, 4 years, give or take.
How do you monitor the activities of guests?
So one, I have all of my listings where I have 24 hours to approve guests. So one, I'm very particular about which guests I allow. We as hosts can give feedback on previous stays. So I make sure that I look at their reviews. So one, I'm very particular about making sure that they're getting a good rating as far as guests go. And then as far as actually monitoring the property, Pullman specifically, this was our primary residence when we bought it back in 2019. So I have very close relationships with the neighbors. I'm in contact, several neighbors that actually use the property as a short-term rental, for weddings and things like that. And so typically they contact us if there's an issue. And from my memory, I've never had any contact from any issue so far. The other property owners, I own it with my father and mother-in-law. They also live like 5 minutes away from the house. So
you maintain some sort of communication with some of your neighbors?
yes, yeah, most definitely.
And let's say I wanted to do a short-term rental from your
Yep.
property.
Mhm.
You would check my ratings? How would you do that?
It's on the Airbnb or VRBO site. So if a request comes in, because there's two different options. So there's one option where it's instant booking. I have that turned off. So I have 24 hours to approve. So you would send in a request. I would then look at the dates. I then can look on your profile and it will say like you've had 7 past stays and you have from other hosts have rated you 4.9 out of 5 stars. If a guest has less than 4, that is a pretty big red flag to me. It's pretty hard to get not 5 stars as a guest, in my opinion. So most of the time, all the guests have 4.95 stars. And very rarely do I accept anything that's less than that. So
Most of your guests have done this previously?
yeah.
And so they have ratings?
Yeah. And I have a few guests that return. For example, they have family in the area, so they come every year during summer, so they will use the property. Lots of the guests are family members of surrounding college campuses. Their students go to Willamette or Oregon State, and so they're here for graduations, or they're moving their child into the dorms or things like that is usually who the guests are. Sometimes it's people for work. So their companies are booking for their staff and yeah.
Let's say one of your guests is incredibly noisy.
Mm-hmm.
What do you do about that?
Well, I've never had that issue, but if it was brought to my attention, I would then contact the guest and let them know that that's not acceptable. If that remains an issue, I would either personally probably show up at the property or have the other owners show up to try to have a discussion. I have never had to kick a guest out, so I don't know what that process would look like as far as Airbnb
You have a
goes.
contractual arrangement with your guests, right?
Yeah,
They have certain rules they have to
yeah,
follow.
yeah.
And I assume the contract gives you the right to kick their asses out of that.
I would guess, yeah, I think if they're not following noise ordinances in the city, then yeah, it's pretty obvious. And then if something had to happen, obviously we could call the police department, things like that if needed, but yeah.
This house has regular trash collection, but
Yes, yep, it gets picked up every Thursday. It also has yard maintenance. Our yard is very well upkept. It has yard maintenance once a week. So yeah, for the front yard, so.
the member of the public that commented
Yeah,
raised a lot of issues that are hard to address.
Yeah.
Talk about property values. And I guess I'm asking you,
Mhm.
who have experience in this, have you ever noticed that sort of thing?
No, I actually, in my personal experience, because it was, like I said, our primary residence, we then tried to do a long-term tenant in the property. We did that for a year. And we switched to a short term mainly because I actually feel like I have a better eye on the property and the condition that it's in. With a long-term tenant, you're not getting eyes on it as regularly. With it being a short-term rental, I'm having it upkept weekly by the yard maintenance crew. I have a cleaner that goes in there multiple times a week, depending on turnover. And I get to see it with my own eyes at least once a month. So in my opinion, I feel like my house is actually better taken care of than a long-term tenant. which should then essentially increase the property value, if it ever comes time to sell. Because just we get to have more control over how it's being treated and all of those things, versus with the long-term tenants, you don't get as much control. So,
Final question is, you lived in the neighborhood for some time?
yeah.
What's the neighborhood like? Is it a mixture of residential uses, retired people, people that work around Salem, other other short-term?
I don't know of any short-term rentals in the neighborhood necessarily. I did live in the neighborhood for 2 or 3 years when we first bought it. And yeah, I would say it's a mixture of people that are retired, people that are working, families, lots of people that are constantly going on walks. I feel like it's a super safe neighborhood. It's actually a big feedback that I get from guests is that they feel super safe and at home, which is important to guests. And
Is there
yeah.
any security issues when you lived?
We one time had a trailer, a RV trailer that we were renovating on the street parking. And the battery got stolen out of the front. That's the only issue we've ever had. But I mean, at the property, like I'm sure you could see on the site plan, we have lots of space. We have the 2-car garage plus lots of space in the driveway, and we also have RV parking that is behind a fence. So most guests, if they're bringing trailers or things like that, they're parking it back. So.
That exhausts my questions.
Okay. I do have one question for maybe the planning division. I don't know if it's necessarily up to you. I was curious if we did come to sell the property, do we know if this license, if approved, and this conditional use permit would be transferable?
Yeah, so part of the.
It is unless it's conditioned not to.
Well, so actually there's in SRC 300.820, so basically the text of it says that we can't impose any permanent condition which would limit use of the subject property to one particular owner. So part of the code says that we can't necessarily impose a condition that limits it to one particular owner, so it would still have to run with the land.
Okay, I just was curious because in my opinion, it would be of value to the buyers if we could say that it was already approved and licensed under the circumstance that it would be.
The approval may change if there's like additional changes proposed to the property.
Yeah, right.
So then that would modify the original approval.
Yeah, but as long as it stayed exactly the same, you're saying it would be.
That's my understanding,
Yeah,
yes.
okay. And I don't have any desire to sell it. I was just curious if we did at some point in the future.
Yes.
Yeah, it's a 300.820 A2.
Open the questions.
Okay, thank you.
Are others in the audience who wish to testify? Seeing none. Comments,
Nope, I don't think so.
final rebuttal. Sorry.
I think we're good.
Okay, let's close the hearing. I'll try to have my decision out no later than Monday. Approving the conditional use permit,
Awesome.
maybe Friday. Who knows? We'll see. So thank you.
Yeah, thank you.
Yes.
Thank you so much.
Hey, I mean, thank you guys.
It's nice to not get stolen. So.
Yeah, that's the first time that's ever happened, I think. It's and because I'm sure you saw it in the staff report that one of the hearing notice signs, well, both of them were taken
Taken.
off the property.
Yeah,
And so we had to replace them. And
I've been checking every day to make sure that they're still in the camera view.
One thing you didn't say is that you do have the property monitored with the Ring camera
Yeah,
also,
I
that is
have to.
recording. So she monitors what's going on the
Yeah,
outside of the house.
yeah.
Who's coming and going in the house.
Yeah.
Not inside the house, but on the
Yeah.
exteriors.
Yeah.
Wait, can we reopen the record?
Say that.
There is a permanent camera that you have on the property that monitors it.
Yeah.
Okay, well, that's,
Significant
What can you
information.
say?
yeah, and lots of-
okay. Let's close the hearing again.
Sorry about that.
I mean, your presentation was way longer than mine, so it's, hard to get everything.
Yeah. All the details.
Yeah.
So those signs just have to be returned within 7 days, is that
Yep.
what I remember? Okay.
Yeah, just within a week from today.